Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to have Case Time Story Hour again, and this time we're going to talk about a case from Mississippi. Actually, two cases from Mississippi, because it's a wild one. Stay tuned. I had a former boss who said that you really needed a passport to visit Mississippi. And he said that because he thought that Mississippi was so unlike the rest of the United States. Now, I don't think you need a passport to visit Mississippi, and I don't really think that Mississippi is all that different. But there are a lot of different kinds of people in Mississippi, and I would add in Alabama, where I sometimes reside. So we're going to talk about one today, and his name is James Newell. This case, Newell versus State, is a Mississippi case originally from around 2010, and we'll talk about what happened. So James Newell had an on-again and off-again relationship with a woman that he married named Diane. After they had been married, and interestingly enough, the marriage only lasted 2 weeks, probably because she knew he was going to be spending a little while in lockup. But anyway, he decided that she was cheating on him, and so he went to the bar where he knew she would be. Now, James worked in Mississippi, but he lived across the state line in Alabama. So he goes to this bar, and in the parking lot, he sees her truck, and he walks up to somebody who's leaning on the truck and says, "Do you know the gal who drives this truck?" And he kind of got a grunt. And then the guy asked him, and then he asked the guy, "Do you know where she is?" And he started to give James a ton of grief about that. And as a result of that, what happened was he followed James back to his truck, and in the course of following him back to his truck, proceeded to assault him. And so James drew his firearm and shot the man. Then, because James didn't think he could get a fair trial in Mississippi, and unfortunately there does seem to be some truth in that belief, he immediately fled to Alabama. Okay, so let's back up a second. Before our brain surgeon from Alabama here had his encounter with the gentleman in the pickup truck, several hours before, after he had figured out that she was cheating on him, he called her cell phone and left messages saying he was going to kill her and he was going to kill the boyfriend. So it's always a really smart move when you're planning violence, to give notification that's recorded and that can later be used against you and that you really can't deny because the records are going to come in. So he makes these calls, and then a few minutes after he makes the call, he calls back and says, "Never mind, you two aren't worth it." But then, for some reason, he decides that they are worth at least going and harassing, so he drives over to Mississippi. So the first issue in the trial court was, can we admit these nasty messages? Because the man that was shot was not her boyfriend, was simply a friend of both her and the guy she was cheating with. And he had never made a specific threat as to that individual. But the trial court, on really spurious grounds, I think, admitted that evidence. It said, look, he threatened to kill somebody, so certainly he must have had homicide on his mind. That's, again, I think it would be a relevance question for most courts, And I think most courts would likely keep that out of evidence. But the Mississippi Supreme Court said, go ahead. What do we care? I'm sorry, the Mississippi Court of Appeals said, sure, go ahead, admit this evidence because it tends to show a propensity for violence, even though propensity evidence is generally excluded. So the next thing that the trial court did when the medical examiner testified, the defendant went to cross-examine him on the issue of the toxicology. In other words, what exactly was in this guy's blood that he would try to crawl inside my truck and kill me? And the trial court refused to allow the medical examiner to discuss the toxicology. So that was the first thing that the Mississippi Court of Appeals said, no, you made a mistake here, Judge. And that was sufficient to overturn the verdict. But the court didn't stop there. The other error that was asserted that was of critical importance was a Castle Doctrine defense. And basically what the court said was that you can't have a situation where somebody is trying to break into a car and the break-in is only occurring while their body parts are inside the car. Let me read to you that portion of the opinion. Here's what the appellate court said. Although section 97.315 sub 3 does not expressly refer to the location of the person who uses defensive force, it does refer to the vehicle which he was occupying. And section 97.315 sub 3 also states that if the person who uses defensive force is entitled to the presumption only if the person against whom the defensive force was used was in the process of unlawfully and forcibly entering an occupied vehicle, or if that person was attempting to unlawfully remove another against the other person's will from that occupied vehicle. So the statute requires the person who used defensive force to have been occupying his vehicle, but it does not expressly refer to when exactly that person must have used his defensive force. Now, one of the things I believe I may have left out when I was talking about the facts is that in addition to trying to get into the truck, he said he was going to pull him out of the truck and beat him. And he had closed the truck door on Newell's leg. So there was a lot of evidence here that he was serious about assaulting and harming Newell. So the court went on to say this: if the occupant is still in danger after exiting the vehicle, and he is still in the immediate premises thereof, he should be allowed to use reasonable force to defend against the danger and still be presumed to have acted in reasonable fear of imminent death or great bodily harm. And they cite the statute, Mississippi Code Annotated 97.315, subparagraph 3. So there you have it. You have a situation where somebody is trying to be forcefully removed from the vehicle and actually steps out of the vehicle in order to shoot the man. That was where, if he made a mistake, that was where he made a mistake. But I told you this was about 2 cases. So what happened? Well, on retrial, which happened about 2 years after the initial trial in 2012, the trial court again excluded evidence, again admitted evidence that it should not have admitted. In this case, it was evidence from an expert who was not qualified to testify on the subject, and the expert evidence basically it wound up being pure speculation, had no basis in the actual facts of the case. So as a result of that, the Court of Appeals again reversed the conviction, and it went up to the state Supreme Court, and the state Supreme Court affirmed that reversal. Now, I have followed up on this a number of times trying to find out if Mr. Newell has been retried a 3rd time. If he has, I haven't seen any evidence of that. But I know that at some point that trial will take place, or it may already have taken place, and you should have a verdict for it. But for whatever reason, the media is not reporting on it. And as I may have mentioned before, a lot of times I think when the media doesn't report on things they don't want people to know, they can defend themselves. And indeed, you can defend yourself if you stick within the confines of the law. Now, if we want to talk about some of the mistakes that Newell made, the first mistake that he made was fleeing the scene, because flight always makes you look guilty. The prosecutor will stand up and say, hey, if the guy didn't think he did anything wrong, why did he get in his car and hot-footed over to Alabama? Well, of course, the reason here is because he was afraid that a Mississippi jury would be a hanging jury. And indeed, that is sort of what happened here twice. But that's a big mistake. You always want to stay, you want to engage with the police and explain what happened. You want to point out evidence, and you want to tell them, I need to speak to my lawyer before I give a statement. You know, basic facts are, I was attacked, I had to defend myself, I'll give you a complete statement, I'll cooperate fully, but first I need to talk to my attorney. And if you don't have an attorney, that's a bad thing. You should have an attorney. If you don't have an attorney, you need to have one of the many companies that provide self-defense insurance. I myself am insured through USCCA, the United States Concealed Carry Association, and I keep my policy up to date at all times because, generally speaking, homeowners insurance will not help you out in a situation like this. And there's a good chance that even if you prevail on the criminal part, that you will get sued civilly. So it's a good idea to have that kind of insurance. So thank you very much for watching. If you have any questions, please leave them down in the comments down below. Give me a thumbs up if you would. You know what to do. Like, share, subscribe. If you have any questions or comments, leave them in the comments down below. And if you haven't done so already, go over here and subscribe to our channel. Tap on the notification bell, and that way you'll be notified whenever we release a video on this channel. Thank you so much for watching. Have a great day.